Are you typically one of those people who has everything together? Like you don't crack under pressure normally, but now that you're in family court, everything seems to be unwired, out of control, and unmanageable? Well, there's a reason for this, and I'm going to talk about that today. So stay tuned.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
Well, hello there. It's Tracey Bee, and you're listening to another episode of Self-Represented in Family Court, where we discuss strategy. That's our focus. That's our mission. That's what we talk about. So, I wanted to talk about something that actually has been lingering in the back of my mind for several months, but I never took the time to really address it. I notice that people automatically go into panic mode or become overwhelmed with anxiety just from the mere mention of not the soon-to-be ex, because that's understandable, or the opposing party. No, just the mere mention of the process, the case, the D word or the C word, and the thought of actually going through it. Not the emotional part, just the process, just the formalities, just the logical aspects of it, in addition to the emotional. But the emotional part, we understand that. But people are really struck, overwhelmed, drowned with fear and panic and anxiety and worry and overthinking and paranoia. And I can go on, but we'll be here until this time next year, just from the mere thought of going through the process. And understandably, right? But the problem is, some of those very people are usually the people that have it together. They don't crack under pressure. They don't lie awake at night, tossing and turning, overwhelmed with worry or fear or doubt. They're usually pretty on point when it comes to problems, conflict, challenges. Not that anybody wants them, but they're usually able and capable of handling those things. Even those people, though, are sometimes stifled with fear, with doubt, with overwhelm, with anxiety, with, again, we'll be here until next year, when they get embroiled in a family court, particularly a high conflict, sometimes mid-conflict family court case. And that's what I call litigation panic. I'm not talking about the normal stress of trying to facilitate things and understand things and navigate things. I'm not talking about the emotional part where you're sad or you're angry or you're in shock or have regret. I'm not talking about that. I'm talking about the fear that starts controlling your perception of everything. The fear that creeps up and makes you doubt who you are or what you're doing, or if you're competent, or if you're mentally stable and or insane. I'm talking about the people who, before this process started, usually had a handle on things. And now the litigation panic has taken over. And it's also, when you're in survival mode and you are no longer thinking critically, you're no longer using those problem-solving skills that you've mastered, maybe because of your profession or the line of work you did or the roles you play at home or in the community. You were that person, right? The litigation panic it's usually when the emotional relief becomes more important than the long-term positioning. Just trying to make it through the next issue or the next appearance or the next exchange is all you can focus on. That's what I mean. And again, it's particularly relevant to the people who, prior to this, things like those were a breeze. So that's what litigation panic is. And the reason I'm talking about it is because it does wreak havoc on cases that should not have havoc wreaked on them. I just made that up. But yeah, there are some cases that you could, yes, you, self-represented or not, you could get a handle on things, manage to get through the conflict, manage to keep your emotions in check, manage to be organized and coordinated and prepared and ready. You can manage to be an integral, helpful participant of your case in your family court case. You can do that because typically that's who you are as a person. Whether you're type A or, you're one of those people that's just this pillar. You are not immune. You are human. It's possible. It happens to the best of us, of you. And so this is not a let me bash on you and let me make you feel worse discussion. That's not my point. That's not my focus. That's not my intention. My intention is to let you know that not getting a handle, not being that person you are capable of being, allowing the litigation, the process, overwhelm you when you typically are not that easily overwhelmed, can have a negative, destructive, not so good impact on not just the outcome of your case, but the overall process itself. So why does this happen? Why does this happen to the people who are type A, who are the critical thinkers and the problem solvers and the leaders and the, the managers and the CEOs, and because those are the people I'm talking about. Why does this happen? Especially in family court, because family court has this way of creating a unique type of mental, psychological pressure. There's no other venue, not criminal, definitely not civil, not immigration. There's no other court venue that imposes such psychological pressure on the people who are in their environment, that environment. It's the uncertainty, it's the lack of control, it's the fear of losing your stability, losing your financial future, losing your children. It's the financial instability and unpredictability. It's the I don't know who I am anymore, the identity collapse. It's the judgment. It's the determination from outsiders that you are this person, that they may not be accurate, they may not know, they may see you responding or reacting in a way that's not typical of you, and so you have to deal with that judgment. That's a psychological impact. That has some impact on your mental acuity. How about just the intimidation of the process, not knowing, especially if you are in management or a C-level sort of role in your business or in your company, and you usually are really astute and on top of things and in control of things, and in this environment you are easily intimidated, you're vulnerable, because family court has a way of doing that to the best of us. As I said, it's the confusion about procedure. You don't know procedure. What else compares to family court? You've never gone through anything remotely similar to family court. So the procedure, the process itself can be really confusing and overwhelming. And it's the chronic hypervigilance where you always have to be on guard. You always have to be on. You always have to be like uber alert. You always have to be completely aware and cognizant of every little thing that happens. All of those things do have some play. It creates an environment. It leads itself to actual having you undergo constant mental, psychological pressure. That's what family court does. It's not just the conflict. It's the environment, it's the structure, it's the dynamics, it's the rules, it's the law, it's the people, it's the energy. It is set up. Yes, it is designed to impose exactly what you're being subjected to. The mental warfare that is compromising your ability to function at the level you're typically or you're used to functioning at. So let's talk about those early signs of panic and when it actually does start to creep over into your ability to think clearly and to function the way you used to. You start doing things like, I see this a lot, where people are constantly second guessing their decisions. They get really desperate, they start asking strangers to help them make decisions that they would normally make in a split second. They're relying on strangers who know nothing about them, their dynamics, their situation, their case, their background, their facts, their history, but they're asking them and are relying on them to help them make not just minor decisions, I'm talking major decisions. That's when you know. How about when you start filing things? I've just spoken to someone yesterday, highly educated, very articulate, and she told me that she was filing here and there and she did not understand why every filing was being ignored. And I mentioned that she's highly articulate and educated and very smart woman, but didn't understand why her consistent filings were falling on deaf ears. That happens. Now, I know better, but she didn't. Once I explained to her, though, she instantly got it. But you see where I'm going with this? She was, fell victim to the litigation panic. Her panic was she wanted to keep filing, whether it was in response to the other party's filings or it was her own filings that she initiated. The repetitive filings. That's not necessarily the sound or the best way to move forward or to get something accomplished or to reach your goal. How about the emotional spiraling when you hear the judge say or make a ruling that you don't necessarily agree with or that you don't understand how they came to that? The emotional spiraling when you're typically very poised and you've been very regulated and pretty much calm, and then you start to react to everything the judge says that's not in your favor. These are signs that you're, starting to fall prey to the litigation panic, and you're no longer thinking clearly. You're no longer being strategic. Not to say that you can't get back from that, but these are signs. How about firing your lawyer? I know every day, every single day, I see or I read or I talk to someone who's telling me that they're firing their lawyer because the lawyer didn't get them out of a situation that they wanted to be relieved from. They wanted help in a situation that the lawyer did nothing or did very little. And yeah, I know it sounds like, well, Tracey, what are you talking about? That's what we're paying them for. Well, you know what? The lawyer is not a magician, right? And there are some bad lawyers just as there are bad teachers, bad cops. But if your lawyer is bound or restricted or limited in what they can do and cannot do, firing them for that reason, for that basis, doesn't make much sense. And if you think about it, especially if you're in a profession where you have to respond or you have to abide by rules that are issued by a governing body, You know that there might be some things you want to do, but there are times when there are things that you cannot do because of those rules, those regulations, those principles that are issued by the governing body. So you know that in your line of work, but you get to family court, you work with an attorney, and all of a sudden that logic goes out the window. Again, there are times where, yes, there are lawyers who don't do anything, and it may not be the rules, the ethical rules, for example, but it could be some understanding of the way the judge operates. If your lawyer doesn't file a contempt motion and you really want them to, and you really think you need them to, but they, choose not to or refuse to because they know your judge will not actually rule on it or won't even entertain it, then it's not a question of, whether the lawyer is effective or competent or, working with you. It's sometimes that's exactly what they're doing. They're looking out for your best interests. But yeah, when you start to question everything the lawyer does and does not do, especially, like I said, when you have an idea because of what you do, the line of work you do, or the profession you're in, you have an idea why there are limitations, or you have an idea of their strategy if they discuss one with you, or they've been on point up until this particular issue, then yeah, you might be finding yourself subjected to litigation panic. And litigation panic is not a bad thing, but it definitely can creep in, and destroy all your efforts. How about, this is my favorite one. This is an indication that you are being subjected to litigation panic. The over documentation of everything. You document everything, every single detail. You document that, and then you think that the judge is going to actually take the time to go through everything you documented. That is my favorite, because so many people, I can't tell you the number of people, not just litigants either. There are these experts, I don't know what they're calling themselves, but they're popping up all over the place, selling these services where they say, hey, I'm going to show you how to document things. I created a tool that's going to help you document things. I'm going to make sure you get your case, your objective you're trying to achieve in family court, because I'm going to show you how to document. I created this tool. Look at my tool. It's going to help you document. It's going to help you organize everything you documented. It's going to help you present all the things you documented. And I laugh now, because when you fall for that, yes, you've just been bitten by the litigation panic bug, because there is no need to document every single thing. There are some things you should document, but after a certain point, when it gets to a certain point, there's no need to document everything. What you need to start doing is strategically documenting things. Not everything. I purposely did not say everything. You strategically start documenting things, relevant things, key things, important and relevant key things to your judge. Only your judge. So, those are some of the scenarios. But Tracey, how does those things destroy my case? How does questioning my lawyer's ability or unwillingness to file a motion that I think should be filed, wanting to fire them over that, how does that destroy my case? If you're impulsively firing and hiring lawyers without using logic, without being strategic, if you're filing motions and petitions or responding to them because you're frustrated, because the other party is antagonistic, because things have been stalled long enough. Whatever the reason, if you're doing that and that you're not being strategic, if you make any move without being fully informed or without being sure that it fits into your overall strategy, and that's what litigation panic does, you act impulsively, you don't necessarily think, you don't incorporate strategy. Those are surefire ways to get your case to go downhill really quickly. You don't want that. What can you do? If you are a kick-ass supervisor, manager, C-suite, if you are a leader, if you are type A, if you are super put together in any other context, in any other environment than family court, then you're going to have to learn to use, to tweak, to master those skills that has gotten you here. It's not hard. It takes time, it takes effort, it takes attention and focus, but it's not hard. Where do you start? You start by creating guess what? If you said strategy, you're spot on. Starting with creating, just like you do a SWOT analysis, depending on your role in your business or your company. You've done a SWOT analysis for your business? Have you? If not, try it. Do one for your family court case. I actually have a tool that I created when I first started this, where I was giving people this tool for free, where it walked them through a SWOT analysis. Since that time, I've actually made that a proprietary tool where I use my advocate method. It's my advocate method that allows you to create a strategy that's going to help you stay focused, stay grounded, and stay protected, immune to the typical pitfalls of litigation panic. If you want to work with me and use that tool to create a strategy, a solid strategy that's going to keep you focused, balanced, grounded, functional, let me know. I use that tool when I work with people one-on-one in my case map programs. 4 weeks, 12 weeks, or 24 weeks. We can actually do that. It might, it won't, there's no might. It will help you, I can assure you, especially if you can understand the importance, the need for making sure that you are focused and that you're sharp and that you're astute enough to see what's going on. Because family court will completely derail everything you've worked on if you don't make sure you have something or some things in place to keep you on track, to keep you informed, to keep you alert, to keep you on track. So that's it. That's all I have for you today. Thank you so much for tuning in. If you are interested in working with me on strategy to ensure that litigation panic does not creep in and completely demolish, destroy your case, please feel free to reach out to me. Use the link in the bio in the show notes, and we can get started as soon as you do that. Until then, we'll talk soon. Take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.